Buenas and half a day. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. Today's Monday, July 24, 2019. The time is 9:04 a.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on July 17 and on July 19, 2019. The notice was also published in the Guam Daily Post on July 16 and 19, 2019. We have 3 agenda items today. Bill 157, Bill 171, and Bill 172. Bill 157 is an act to add a new section to Chapter 89 of Title 9 Guam Code Annotated relative to requiring convicted sexual offenders whose cases are under appeal to retain their absolute duty to register at the Judiciary of Guam Probate Division as a sex offender. This bill was introduced by Senator Amanda Shelton. Bill number 171, introduced by Therese Terlaje, an act to amend Section 4401C of Chapter 4, Article 4, Title 7, Guam Code Annotated, relative to limiting magistrates from handling cases involving felony charges, criminal sexual conduct charges, or repeat offenders. Bill number 172, an act to amend Section 80.14 of Title 9, Guam Code Annotated, and Section 80.76 and 80.78, both of Article 5 of Chapter 80, Title 9, Guam Code Annotated, relative to ensuring pre-sentence reports and assessments are utilized by the Guam Parole Board prior to the release of any offender on parole. Bill number 175, introduced by Senator James Moylan, relative to limitations to loitering in certain areas for registered sex offenders. I'd like to thank my colleagues for attending this morning, starting with our acting speaker, Senator Amanda Shelton, and Senator Terlaje, and Senator James Moylan. Thank you all for being here this morning. We'll now begin the public hearing for Bill number 157, and I invite the sponsor, Senator Shelton, our acting speaker, to introduce the bill.
Hafide, good morning. Thank you very much, Madam Chair, and I thank you for hearing this bill today. I'd also like to thank the co-sponsors of this legislation for signing on, and I thank our colleagues in advance for their support. Sex offender registries are a vital tool in informing the public and preventing further victimization. Survivors of sexual assault whose perpetrators are under appeal have found that their perpetrators have not had to register with the Sex Offender Registry and have gone on to work in similar environments. This potentially puts a new population at risk. The Guam Sex Offender Registry was established by Public Law 25-75 in 1999 with the intent to protect members of our island community from sexual offenders by monitoring those offenders and making their information accessible to the public. This information includes the name, date of birth, list of offenses, home address, work address, physical description, headshot, and known vehicles of the offender. This database is vital to protect existing victims, to deter recidivism among offenders, and to prevent future sexual offenses. In 1994, the U.S. Congress passed the Wetterling Act, which mandates that all 50 states maintain a sex offender registry. A study published in the Journal of Law and Economics finds that registration reduces the number of sex offenses by about 13%. Bill 157-35 closes a loophole in the sex offender register law by mandating that convicted sex offenders comply with the requirement to register on the sex offender registry even when the convict files for an appeal. The record of the conviction and appeal is public. The Sex Offender Registry would simply make that information more easily accessible. I want to thank the Attorney General's Office for providing input of ways to strengthen the language of the bill. I welcome the input to make this bill stronger from our colleagues and from the public today, and give our people greater access to information of convicted sex offenders in their area so they can make the best decisions and remain vigilant for their children. So Dios Masi. And I'd also like to thank the survivors who were instrumental in helping to craft this legislation, who I've been working with over the past month. So thank you very much, Madam Chair, for this opportunity.
Thank you very much. I'd now like to call those who've signed up to testify today, including Mark Perez and Michelle Taitano. Tom Van Engen. Mr. Van Engen, you may begin.
Appeal, how do they get it cleared? I've heard, I don't know this for sure, but I've heard that it's very difficult to get unregistered when it is appropriate to do so.
Thank you very much for that question, and it has been a concern that was brought up, and so we are looking at language to include in the bill to ensure that if a case is turned over on appeal, that there is a mechanism to do that right away.
Thank you very much. Mr. Van Engen, am I saying your name correctly? Engen?
It's a soft G, yes, Van Engen, like Manilao.
And Enning.
Engen, yeah.
Okay. And Ms. Michelle Taitano?
Yes, thank you, Madam Chair. Good morning, Senators. Thank you, Ms. Shelton, for crafting this bill. It's a good bill. I'm thankful that the loophole was identified and that you worked with the Attorney General to craft it. So I just want to say thank you because it does clarify further to protect the public. So thank you so much.
Thank you. And Mr. Perez?
Yes, thank you again. My only comment for this bill, I do support it, but also asking that the crafters add more teeth to it by making it mandatory upon conviction, not upon sentencing, upon conviction, so that as soon as they have that date in the system, it's mandatory that they get registered. This can be done whether they are going to appeal their case or not, working at corrections. They can be convicted one day and not be sentenced for weeks. And so it would be best if the intent is that they get registered right away. That's it.
All right. Thank you, Mr. Perez. Are there any questions for this panel from any of the senators? Senator Taitagui.
Thank you, Madam Chair. I'm Mr. Perez. Where are you from?
I'm from the Department of Corrections. I'm a social worker there.
Okay, and as well as.
I am currently the acting chair of the Guam Parole Board as
Michelle.
Michelle's not
Everybody knows Michelle,
chairing
yes.
anymore.
Okay, thank you so much. And I greatly appreciate both of your comments were spot on as far as like making this a stronger bill. I am concerned, especially about once they're convicted, but going into appeal, if they found in appeal that were not guilty, then how are we going to take this out? So I'll be working closely with the author to ensure that that's possible. And of course, Mr. Perez, what you said makes quite a bit of sense too, because it takes some time after you're convicted to go into what your sentencing is. So I greatly appreciate you being here today and providing some more input to this bill. Thank you so much.
Is there anyone else who would like to testify on Bill 157 regarding the Sex Offender Registry? All right, if not, thank you very much. Would you like to close on the bill?
Sure. Thank you very much, Madam Chair, and I'd like to thank everyone who came out to testify today. We will take in the comments to strengthen the bill, and I'd also like to mention that we received testimony from Ms. Hannah L. Rabadullah in support of Bill 15735, and I'd like to thank everyone again who has helped to craft this legislation as we do our best to help protect our survivors and help to prevent a re-victimization. So, just Masi.
Thank you, Senator Shelton. I'd also like to add that we have a testimony as well from Karen Carpenter regarding Bill 157, and she says there would need to be a mechanism so that the name could be quickly taken off the sex offender registry if the case were overturned on appeal. Karen Carpenter. All right, and so we will await further input on the bill from we're going to follow up on the input from the AG and further input from our Legislative Council. Sidus Masi to all those who testified on Bill 157. I will continue to accept written testimony until the close of business on August 7, 2019 on Bill 157. The time is now 9:15 a.m. We will move on to the next item on the agenda, which is Bill 171, introduced by myself with the co-sponsorship of all my colleagues of the 35th Guam Legislature. Could I get the sign-in sheet for Bill 171? Bill 171 is an act to amend a section of the Guam Code annotated relative to limiting magistrates from handling cases involving felony charges, criminal sexual conduct charges, or repeat offenders. It's one of a trio of bills introduced after several public hearings or roundtables and meetings and discussions with various stakeholders within the justice community, where it became clear that criminal sexual conduct offenders were being released into the community without adequate risk assessment, treatment, or rehabilitation to protect the community against repeat offenses. The intent of Bill 171 is to ensure that decisions involving felonies, criminal sexual conduct, and repeat offenders are handled only by judges who are subject to retention election in order for these decisions to remain subject to public review and accountability, and to be consistent with the interests of the community. The bill also expands the authority of magistrates to preside over treatment court status and progress hearings upon appointment by the presiding judge. This may help to clear the judges' schedules a little so that they can in turn handle the felony cases. I believe this bill is consistent with judicial efficiency and yet keeps accountability for release decisions by those directly accountable to the public and the community. Bill 171 specifically amends a section that lists the duties of a magistrate. It says, as assigned by the Chief Justice, a magistrate shall. So currently, a magistrate shall preside over first appearances of criminal defendants and arraignments in criminal cases, set bail and order pretrial release conditions, take pleas, including accepting guilty pleas in misdemeanor cases, sentencing misdemeanors, and entering judgments accordingly. And so we are adding that a magistrate shall not preside over cases involving felony charges, criminal sexual conduct charges, or repeat offenders. There's another section of the magistrate's duties that allows a magistrate to preside over preliminary hearings in criminal cases and render decisions and judgments over procedural and discovery motions in criminal matters. And we're also adding an exception there that a magistrate shall not preside over cases involving felony charges, criminal sexual conduct charges, or repeat offenders. And then we add a provision to the magistrate's duties allowing them to preside over treatment court status and progress hearings upon appointment by the presiding judge. We'll now accept testimony if there's any signed up for Bill 171. Staff, is there a sign-up sheet for Bill 171? All right. There being no one signed up to testify on Bill 171, we will proceed, unless any of the senators have a...
I just want to make a comment.
Sure. Senator Taitukui.
Thank you, Madam Chair. I just wanted to make a comment. I think it's important that the judicial branch should have been here today and provide testimony, and I request that the chair please look into, their comments on this moving forward. And that's all. I just wish they were here today.
Yes, I've extended an invitation to every judge and justice, and hoping for their testimony. I was told off the record that they may be prohibited from testifying, but I will follow up on that, on bills. And, all right. All right, if I may depart from the agenda a little bit. I know I said I closed the hearing for Bill 157, but a couple people came in later, and I'd like to reopen the testimony on Bill 157 if there's no objection from my colleagues. And so I will call up to testify on Bill 157, Josette Canata and Rose Hermoso. Good morning. All right. Josette, you may begin. Oh, okay, Rose, please.
Thank you. Good morning, Senators. The reason why I'm here is to support Bill 157-35. And so first I want to be clear that I'm here not as a Government of Guam worker, but as a victim turned survivor. And now really I could proudly say that I'm an advocate on behalf of this bill. The journey itself started 10 years ago. And I'm not going to go into the details of what had happened. But the fact that 10 years ago, I was raped by the professor at the University of Guam. 5 years later, he victimized 3 other women at the University of Guam. 2 of those victims are still close, really good friends of mine. We're each other's support system. And fast forward though, September 2018, when I returned back on island, the first thing that I did was check the Sex Offender Registry. Now, we're not asking, what I'm saying, it's me and the other victims in this particular case. And I'm sorry if I'm a bit emotional at this point, but I found out that he's not part of the Sex Offender Registry, even though he's convicted. Now, we were explained that because his case was on appeal, we can't do anything. And we're asking why. The people of Guam put a stamp on it and said, he's convicted, he has the money to do his appeal, so be it. To find out later, too, that he was allowed to leave the island without notifying any of the victims. He left on 4 other instances. On the 5th time, that is the only time that we were informed. And at that time, 2 of the victims, survivor rather at this point, really didn't have a chance to give notification to their employer that there's a court hearing. We were informed 2 days prior to the court hearing. And at that time, Judge Vern Perez said that I cannot even speak because I wasn't named victim. I was just a witness because of statute of limitation. Aside the point, we're still asking why. We're not asking for anything but for him to be part of the Sex Offender Registry and to serve his time. And it's so dismaying to know, but also at the same time, really grateful. And I feel blessed that Senator Shelton really opened up her doors to us after hours just to hear our voices. Mind you, I'm a social worker by profession. The other one is an educator. The other victim is pursuing her PhD. And we're not just anybody who's just asking for anything otherwise, but the true conviction in this matter. Doing the research with the sex offender registry in the nation, I thought that Guam was immune to it because we're a territory. And I'm glad to find out that it's not true. But then there's this loophole. I asked this question when we had the meeting with the OAG, and they cannot give me a straight answer. And because of this loophole, I'm pleading, I'm begging, really stop victimizing other women, other people in this island. A professor once told me in social justice class, everything that's political and personal and vice versa. And at that time, 10 years ago, when I was just getting into the social worker field, I rolled my eyes and said, whatever. But now, in retrospect, it is very personal and it's very political in this matter. And it pains me to know, why does hurt people need to hurt other people? We're just a small group, the three of us in here, at least the three of us that I represent, the victims of elder. There's others. After I came out that I was a victim of that case in March, I was informed there's 2 others who's no longer on island. They asked me, do I know this person? Do I know this person? I was like, no. And then later on in that conversation, I was informed that there were victims too. And because of shame and fear, they refused to come out and say whatever. During that court hearing too, my predator was very maniacal. He would wink and smirk throughout that court hearing. Before that court hearing, throughout, every time he sees me, he will brush off my hair on the side, as if the rape itself wasn't enough. And he's part of our community. He's a big name in the community. He's a professor, a tenured professor at the university. And my story is just a minute part of this community. For those victims who turned survivor and now as an advocate. And I say, let's go close that loophole with Bill 157. Please help the others who's not there yet. Please. Thank you.
Thank you very much, Rose. Josette?
Buenas and Hafide, Senator Therese Terlaje and colleagues. Dunkalu Nasizios Ma'asi for your time in allowing me the opportunity to address this esteemed body of our government. In Anhu Si Josette Marie Lujan Kinata, and I come before you as a member of the Guam Family Justice Center Alliance, a survivor of child molestation, and an advocate. I support Bill 157-35 as I believe this is needed after an offender is charged with sexual assault. In fact, we as a whole island, and not just the survivor, must understand and be made aware of the implementation process of how this bill and related legislative concerns surrounding sex offenders will be established, addressed, followed up, and followed through in order to ensure that our community is safeguarded and able to heal from the traumatic effects of sexual assault. The lack of direct involvement with community members, including victims, survivors, advocates, and their families, must be paramount in the implementation and follow-through process of this and other related sex offender bills. Oftentimes, who becomes part of the roundtable discussions and who are invited personally to provide input are service providers, law enforcement, legal and judicial personnel who discuss policies that might not affect them directly. A failed implementation process and/or a lack of accountability prevents every effort for restorative justice, trust, peace, and safety to be infused in our community after an incident of sexual assault. Healing is inclusive. Isolation can lead to hurt and harm. Therefore, this bill needs to be supported. However, I emphasize that what truly needs to be supported are the very voices of those survivors who are the essence of this bill. It is in listening to their stories that we realize that legislation does not equate to lives, but rather ensures that people are protected over the politics of our judicial, legislative, and administrative systems. Our community does not trust the process and/or the policies that continually negate their concerns and dismiss their pleas. Without proper implementation and follow-through on these legislative concerns and community education, we as a whole island fail in protecting our people, and we indirectly re-victimize the very individuals whose lives are directly impacted by this bill. This is more than a public hearing. This is communal healing. And so I stand in front of you and I share this in a culture and island that often silences taboo topics from abuse to sexuality to trauma to everything before and after, where people cry painful tears, where their hearts are stone cold. It's all fear, no laughter. Where we have institutionalized silence of sexual assault and abuse. The moment we decide to speak up and rise above the torment, it becomes our fault. For instance, I was told from the executive director of the Guam Coalition Against Sexual Assault and Family Violence that I didn't know the culture here, and she wanted to see the speech I prepared for a sexual assault conference. I questioned why, when people were going to listen. Let me say it out loud so you can feel my emotions. Email it to me, she said, to assess trigger words that would have to be eliminated. Why, when all of this is raw truth, shared and articulated in a profound manner that shows how a survivor goes from abused to advocate. She refused and repeatedly said no, and I was taken out of the agenda, completely desolate. Why have someone else share from another region when this is about our survivor stories? Because people talk behind other people's back after they share? I thought, why worry? That's the reality we face and that we need to confront. But I never got a chance to share out loud with her or at the conference. I became so fed up. I resigned. I was done. I asked the board and the evaluator, how can she still silence survivors willing to speak up? Isn't this coalition for us? Nope. I saw firsthand how politics and greed impeded healing and rather perpetuated, tormented chaos. I listened to students as a professor questioned sexual misconduct policy and echoed their concerns. I communicated the need for them to be present in meetings with faculty and staff to help discern policies affecting them directly when an incident of sexual assault occurred. But the communication stopped when their last response was, "We'll involve students as appropriate." My points did not go further. Then the notion that reporting is encouraged, yet follow-through is non-existent, where politics overrule people and the judicial system ensures silence. Of what next and how can we improve so that enough is enough isn't just temporary, but it's unfortunate. No real connection to ending this felt system of exhaustive misery. Where the Office of Victim Advocates react per instructions of administrators, rather than listening to the tormented process where people bleed onto others, desperate to be listened to rather than just pacified, given dignity and respect rather than re-traumatizing lost identities and lives, where fear is a reality and trust is burned and damaged because the guilty freely roam and aren't placed on a sex offender registry that is efficiently managed, as high incidence of child sexual abuse occurs at an alarming rate, yet we dismiss the numbers and minimize the reports as we highlight programs that react, not prevent. Therefore, our response is poor or often too late. As suicide numbers rise and target our young, who are told to silence their depression, don't talk about your past trauma and abuse, are words they hear so often. Our system of care mirrors our legislature, where one thing is said, yet implementation is lost. People say, put your money where your mouth is, and don't realize about the high costs felt by survivors who are shuffled in as numbers in a drive-through system of dollar menus where programs exist to meet funding goals rather than the needs of those who are abused, where a parole board is allowing repeat sex offenders to engage in our community without proper assessment or efficient documentation, causing irreparable damage to those already enduring so much agony as a lack of follow-up was never completed from day one. Where the combo deal was a sexual assault forum emphasized for student extra credit, as a researcher asks a survivor if she has to stay long because she doesn't really understand the topic and her time is limited. Like the ability to request a meeting with the Attorney General due to unanswered questions from at least 2 years ago, but that no one seems to ever mention. Is a reluctance to confront the very fact that we need to talk about sexual abuse in order to be aware and address the issues that continually replay the ongoing nightmares, where the abuse is in that moment, but the aftermath effects continue. Is this how we want to be treated? How would you feel if this happened to you? Counseling offered in a diagnosis becomes your identity based on others' as labels and their own subjective perspective, not your reality. They say go get help from professionals and a licensed individual, only to hear from a textbook response after asking if you are suicidal. I share my identity was stripped and now you're placing me in a box after a 60-minute eval that buries my voice only to be treated by your expertise with no sense of dignity and morale. My past circumstances did not define me, my future or purpose, yet this is too raw, too real for you to respond, as this is true disgust. Your licensing exam does not dictate your power over me. My life experiences validate my voice and my authenticity. To talk story and connect to others in an effort to help them heal, not in a clinical setting, but safe and supportive spaces where we can just be real for who we are and not what we've been through. Drop the mic and pick up a megaphone to break the cycle of perpetual silence and be a voice for the voiceless, the epitome of resilience. So I'm here today for those who have yet to find their voice in a culture of silence. To be you and be your most vulnerable self, may you find strength and confidence. To share your story in your voice and be your authentic self. Know you're more than enough and your healing and truth are invaluable wealth. So I ask you to support and to help heal our community.
Thank you, Josette. Dr. McNinch.
Thank you, Senator Terlaje and honorable senators. My name is Ron McNinch. I am here as a private citizen, but also I have a University of Guam role. I'm chair of public administration and legal studies at the University of Guam. I teach in the criminal justice program. I regularly use this registry to teach our criminal justice students how to do indirect surveillance. That is, how can you spot people in a community who are doing bad things? And it's a very powerful tool. It's also a very powerful tool for parents who care about their children, particularly when there are people in their neighborhoods who've done these kinds of very vicious acts. I just wanted to give some very brief testimony on Bill 157, and it's basically this. If a person is on appeal after they've been convicted by particularly a jury, the registry really exists so we can identify these people in the community. And Neighborhood Watch, members of the community, if they're under appeal, quite often there are conditions of their appeal. This class of offenders are able to offend because they're able to deny, lie, and manipulate everyone around them. And they will. And if they're on the registry, that's just one additional tool that the public has to identify them if they're on appeal, because there's been no punishment used against them yet. And because they lie, deny, and manipulate, they can violate the conditions of their conditional release. And so if they're placed on the registry, and if regular citizens know that they're not supposed to be in certain places because they're on appeal, that's just a very, very, very strong tool. In my own case at the University of Guam, we have an offender who denies, even to this day, that they did anything inappropriate. And because they weren't on the registry for so long, that added to the belief or perception people had that they hadn't done anything wrong. So I fully support Bill 157, and I greatly appreciate the opportunity to speak at your hearing today. Thank you.
Thank you very much. Is there any question or comment for this panel? Senator Taitukwi?
Thank you, Madam Chair. And it's more of a comment. You two are really true heroes coming forth and doing this. What you did today may help another victim out there to come forward. You know, they say that a person is defined by how well they stand up after they've been kicked down to the ground, and when they recover, and who they become after is how they're defined. And you two are true heroes, and I want to thank you so much for coming out and testifying on all those people who too afraid to. Hopefully this will give them courage to step forward too. So I want to thank you so much.
Thank you also for your testimony and for your advocacy. I think it's very helpful, and that's exactly what we're trying to do here, is to open up these topics that are not often addressed. And the senators, our acting speakers, found a loophole thanks to your help, and that I, for one, am glad and eager to help to remedy that. So I know that doesn't solve everything, but step by step we're going to address these issues, and we thank you again, all of you, for bringing these to our attention and your advocacy in our efforts. Sizus Masi. We'll now move to the to Bill number 172-35. Bill 172-35 was introduced by myself, and it is an act to amend 80.14 and 80.76 and 80.78 of Title IX Guam Code Annotated relative to ensuring pre-sentencing reports and assessments are utilized by the Guam Parole Board prior to release of any offender on parole. Currently, pre-sentencing investigation reports and recommendations made at the time of sentencing have not been available to the Parole Board when making decisions, even though it is mandated by statute. Criminal sexual conduct offenders continue to be released at the expiration of sentences without an accurate risk assessment, without rehabilitation, as these are not clearly mandated by the law. Risk assessments are not catered to criminal sexual conduct repeat offenders and the risk of harm while on release, and this risk may not be adequately known by judges, Department of Corrections, or the Parole Board at the time of release. Bill 172 will mandate any and all pretrial, pre-sentencing, and incarceration assessment reports be made available to the Parole Board for a determination, before a determination is made regarding a prisoner's release. This is intended to better ensure safety of the public. It's also an effort to eliminate any barriers to the Guam Parole Board's review of any of these pre-sentence and incarceration reports and assessments. It was drafted based on the feedback from the public, survivors, and victims advocates after several public roundtables and meetings. I feel that this is part of our duty to safeguard the peace of mind and well-being of our community and to achieve true justice for victims and survivors of these terrible crimes by closing the gaps that may jeopardize their justice and their safety, and all of our safety. So we will now accept testimony from those on the panel, or those who have signed up to testify, including Mr. Mark Paris, Michelle Taitano, Tom Van Innen, and Dr. Ron McNinch. Mr. Paris, you may begin.
Thank you again. For myself as a social worker at the Department of Corrections, I support this bill, but one question that I have is, what does the word furnish mean? Does it just furnish the pre-sentence investigation a copy, original, that gets taken away at the end after we review it? Are we allowed to make copies? Just looking at the original law, at the end of sentencing, copies are taken back by the court. And then likewise at the roundtable discussion that I attended, the court indicated that although the law says to allow DOC to have a copy or something, there's an alternate law that says not to give it out. I tried looking for that law. I couldn't find it. Does this bill rescind that law?
I tried looking for it also and couldn't find a specific law, so I'm hoping that this bill will just clarify that and make it very clear that any superseding barrier is now removed.
Okay. And then at DOC with the social workers, and I'm sure also with the parole officers, they are in support of this bill because it gives us access to more information. We do have an assessment system that we are currently launching, and it does require us to know some information about the offender prior to getting them. This assessment is dealing with interviews with the client, but having the pre-sentence investigation helps us to validate the information the client is giving. And that way we can truly get a better picture as to the level of criminality the client is at. And then once we get that level, we can determine the amount of hours of treatment that is needed. And so that's it.
Thank you very much, Mr. Perez. Ms. Taitsino.
Thank you, Madam Chair. And thank you, Mark, for bringing that up, because actually that was my concern. We already, by law, already have that in our law to have the information from the courts, but we haven't had it because they haven't given it to the parole officers for some reason. And Mark is saying now that there's an alternative law that's preventing them from saying that. But we do ask, we have asked in the past, and so that has been a continuing problem for many years. So I'm just saying, ma'am, I'm hoping, yes, this will clarify, as you have just said, and make it clear that it will be current and the courts will allow us to access that, because it has been an issue. And again, I just want to thank you for making this more definitive. And with the other sections, I think they were good. And I'm just wondering if, because since it hasn't worked, I'm praying, should let's just hypothetically say they continue to do that, what are the sanctions? How are we going to try to be able to access this information? Because we want to move forward. We want to use those risk assessments that we're in process of. I'm concerned because it just says, and if they trump it, that's a concern that I have, ma'am. But thank you again.
Thank you. Mr. Van Inye.
Thank you, Madam Chair. Thank you, Senators. I appreciate your work on pronunciation. Good job. I share the concerns of Mr. Perez and Ms. Taitino, so I don't need to restate all of that, but this is not the only example of some of the things that are already in law that are not being done. So I would like to take this as a good sign that you'll look into some of those other issues as well, not the least of which is that we should be provided with an executive secretary. I think we brought that up at the round table, and the law says it, but it hasn't happened in the 5 years that I've been on the parole board. So I don't mean that as a criticism of anyone that I know of. I don't know why this happened, but there are several things that the parole board could use more support that are already in law, not to mention maybe other possible improvements. Thank you, Senators.
Thank you. Dr. McNinch.
Thank you, Senator Terlaje and honorable senators. My name is Ron McNinch. In my testimony in support of Bill 172 today, I am speaking as a private citizen. First, I support the bill. I think the more information that the parole board and important agencies have about these important decisions, the better. But I would like to point out one additional point relative to this kind of concept or bill. We live on an island community, and since we live on an island community, we interact with people on a constant and regular basis all the time. Part of the pre-sentencing report, or even the sentencing report itself, is often letters that are written to judges to lobby judges to kind of influence them to sentence in a particular way. And so those letters are not ever made public. They're considered part of the sentencing report. Just yesterday, the federal court released all the letters and all the information in a sentencing matter. There's no reason that these letters written to judges to lobby them should be part of the sentencing report. They should be able to be accessed by the media, by individual victims. After a person's a victim, particularly of a bad crime, if a person from the community is writing a judge to lobby them, that victim has no idea that that person's being supported by somebody that they may have to interact with every day. And so Senator Terlaje, you mentioned the aspect of peace of mind. If a person's a victim of a particularly violent crime or bad crime, and a person is able to, in secret, write letters to judges supporting the person who is the perpetrator against them, that is really fundamentally unfair. And I believe that we should possibly amend this concept a little bit to make those letters public information that the media and individuals can review. If a person's trying to lobby a judge, particularly on behalf of a person who's committed a serious crime, this is a member of the public, people should be able to know about it. In my own particular case, I have to work with people who wrote letters for somebody who did a very, very bad act. And I have to work with them every day. And I have no idea who they are or what they said, or even if their facts are accurate. We have no idea if the things that are being told to these judges in this private manner are even accurate or not. They could be lying to the judge for all we know. If a person seeks to lobby the legislature, their words are open. Their letters are put on your website. If a person's seeking to lobby a judge and influence a judge in a sentencing matter, their words should also be public. Thank you for the opportunity to speak today.
Thank you very much. The testimony is well taken. I want to read out, because I share your concern. So the original statute that controls right now pre-sentence reports by the courts allows for a big exception for the pre-sentence report release, right? So it says that at least 2 days before imposing sentence, the court shall furnish the offender or his counsel, if he so represented, a copy of the investigation exclusive of any recommendations as to sentence, which may exclude those letters, Dr. McNinch, unless, in the opinion of the court, the report contains diagnostic opinion which might seriously disrupt a program of rehabilitation, sources of information obtained upon a promise of confidentiality, or any other information which, if disclosed, might result in harm, physical or otherwise, to the defendant or other persons. And the court shall afford the offender an opportunity to comment thereon. It continues to allow huge exceptions to the release of these reports, even to the offenders. And it sounds like, yes, letters sent in support of a certain type of sentence, or even maybe witness statements. I'm not even sure what these all entail, but it does continue to give this huge gap. Now, I didn't copy these same exceptions on the parole board, but that may be something that needs to be clarified, and whether there is a risk of a parole board seeing this information, let's give an example, that contains diagnostic opinion which might seriously disrupt a program of rehabilitation. Not sure what that means, right? But, and I'm not sure why. I'm worried about a parole board not seeing that. If a judge needs to see those things in order to decide whether to release or not release or to sentence, then I'm thinking the same should apply for anyone who has the authority to release, to give that person back to the community and put that risk on the community, right? So, but your concerns are well taken, and because those are big exceptions in the law. So we will clarify the meaning of furnish, whether copies will be made, and I'm very interested in the assessment tool that DOC is now launching, because I have another bill talking about that. So please, if you could give us the details, that would be great. What is the goal of your assessment tool? But you can just submit that to the committee, and we'd like to work with you. If that's you've got something going, that's great. And as for the other parts of law that are, or this law even, if it's passed, that are not implemented, and what do we do about those things? My advice, being in this job, is the only real remedy we have is to be very vocal, right? You need to be vocal. You need to tell us what the issues are with your board. And so you have, at the roundtables, brought those up. But if I recall the statute correctly regarding an executive secretary, there is a very specific provision as to who shall be your executive secretary, isn't it? And we just need to follow up with that entity and make sure that that happens. But yes, I guess the goal is to raise the concerns and as early and as often as possible until they are addressed. And like we said earlier, at least for this committee, there are many bills regarding how to address criminal sexual conduct in particular. So we are trying to take those one by one and give them the due diligence that they deserve. So any senators have, Senator Taitukui.
Thank you, Madam Chair, and thank you for testifying here today for this bill, which I'm in full support of. But you're right, Michelle, when you mentioned that what about if they don't provide you this documentation? My concern is, where's the teeth? I'm going to work with the author of the bill to find a mechanism to ensure that these documents do get to you, because I do realize your job is very sensitive, and you're working with individuals all the time that can be very intimidating, especially in your line of work, in which my hat is off to you for doing this job at the parole board. Yeah, we need to find a way so that it's very simple. If they don't provide it to you, then this will happen. So I appreciate that input. Thank you so much, Madam Chair.
Thank you, Senator. Any other? All right. Well, again, thank you very much for taking your time to testify on this bill and for your very welcome suggestions. Situus Masi. Testimony on Bill 172. We will continue to accept testimony until August 7, 2019. We will now move on to the next item on the agenda, Bill 175, introduced by Senator James Moylan. So I'd ask the Senator to introduce the bill, please.
Thank you, Madam Chairman. Bill 175, as introduced by myself, also co-sponsored by Senator Nelson and Senator Shelton, is an act to add subsection 8916 to Chapter 89, Title 9, Guam Code Annotated, relative to the limitations of loitering in certain areas for registered sex offenders. This legislation is giving teeth to Guam's loitering laws when it comes specifically to registered sex offenders, where their presence in places frequently by minors specifically for the purpose of bad will. So currently, Guam's law does not have any specific legal mechanism in place to remove a registered sex offender from a public place. The intent of this bill is if someone is identified as an individual who is loitering on public property, that they have the ability to request this sex offender to leave. And if they don't comply to the request, then with the passage of this legislation, they can be charged. The intent of this bill and the reason for it was brought up to us by public safety officials, sharing with us the stories of registered sex offenders going to or attending school sport practices for no other purpose than to be around potential victims, of registered sex offenders hanging out near movie theaters for no goodwill reason at all, or at playgrounds, and recently, the horrific intent at a bus stop. All cases where individuals, sexual offender registered individuals, had no specific purpose for being present at that facility with just that specific intent in their minds, and that's the threat to minors. Now, this bill does not restrict the offender from being in a public place frequently by minors. It does not. As long as they have the intended purpose for being there. If they don't, then they must leave. And if after that intended purpose is completed, they must leave as well. So basically, it would limit their presence for the specific need and then get out of there. So that's the purpose of this bill, and I hope with it becoming law that we can strengthen and protect our victims and protect our society, and especially the most vulnerable, our minors. Thank you, Madam Chair.
Thank you, Senator. I will now call up those who've signed up to testify on Bill 175, Michelle Titano, Mark Paris, Dr. McNinch. Is there anyone else who would like to testify? Please come up. All right, we'll start with Michelle Titano.
Thank you, Madam Chair. Again, thank you, Senator Moylan, for crafting this bill. It's good, and again, it helps keep our children and community safer. I just have a couple of concerns. I like that where it says there's an intent. So if you have an intent, because unfortunately some of the sex offenders on the registry have children, they have families, and if they're going to go and do the sport, they're going to support their kids at a soccer game, they should be allowed to do that. There again, it's intent, and then they leave. But you're right. Loitering, of course, have them removed so that they can get on about their business and we can continue being safe, doing whatever, whether it's sports or an activity. And then my colleague here is going to ask another question about that. But thank you, sir. I support this bill. Thank you.
Mr. Paris.
Thank you. I submitted written testimony, but under the same lines as Ms. Titano, just some clarification may also be needed, in the sense that if the registered sex offender is out watching a basketball game or watching a softball game done at Teason, where it's adults, but there's a lot of kids going around, no coach goes out there and says you're not supposed to be here. I mean, watching is a form of socialization. And so, clarification's needed so that they're not intentionally singled out when they do have a simple intent of watching a game or being playing intramural basketball at a community basketball court, and then there's youth baseball practice going on. Just some clarifications needed, but the intent is very good.
Thank you, Mr. Perez. Karina Fairman?
Thank you. Happy day and thank you. My name is Karina Farron. I am the president of the Guam Family Justice Center Alliance. Definitely thank you for all the bills today. Truly appreciative of every single one of them. Senator Moylan, I do have some questions in regards to the bill. I did go over it again. I definitely for it, but there are a couple of things that I want to express. In particular, I am also a part of the Guam Wrestling Association, in which I put together our referee list on who goes to these sites for the matches. And we had an issue prior to that. My husband also assisted with JFK with the announcing, and there was a so-called photographer that was up there constantly taking pictures, who we did not know was a registered sex offender. And so this was a whole season of him taking pictures and snapshots and claiming he represented a community newspaper. And when it came to the wrestling part, again, saw him again, and was a very friendly person. He insisted that he was also trying out as a referee and trying to get in with our organization. And during weigh-ins, we actually have the students weigh in as with as little garment as they can to make sure that they're precisely at the right measurement. We had discussed with him that he couldn't enter the room, and it was a good thing that we didn't. And only later to find out that match over match, over the course of the season, somebody finally approached us and let us know that this person was a sex offender. And of course, we got together, got a hold of the person in charge of the school at that time, and of course he was asked to leave. So with this bill, it does talk about loitering, but like for him, he's saying a little bit more clarification, maybe more necessary on clarification to make it mandatory for sex offenders to know what the rules and regulations are when it comes to this. For example, that it's against the law to pretend to be a representative of an organization, maybe going to these areas and not photographing. I mean, maybe there's got to be more restrictions on this, and maybe we can assist in helping you when it comes to that, but an additional pamphlet or rules and regulations to assist in promoting and making sure that this legislation is followed through correctly. Thank you.
Thank you. Josette? Dr. McNinch?
Thank you, Senator Terlaje, and certainly Senator Moylan. I also am very pleased with many of the bills this morning. I'm in support of Bill 175. I think that, of course, within the bill-making process, there are always things that we can do to make a bill a better bill, and certainly there are those considerations here. I, again, teach a class using the Sex Offender Registry, and so it got to the point I had to stop teaching it because everywhere I looked, I would see pedophiles everywhere. It was incredible because everywhere I turned, I would see them at children events, like sports events. One was laying on the hood of his car alone within 50 feet of little kids playing soccer, 7 and 8-year-old kids. And that's a pedophile who abused 7 and 8-year-old kids. And there was no reason for him to be there. I can go through plenty of examples where I see and encounter with these folks who have no business, and in fact, it's beyond loitering. They are seeking to directly encounter and interact with children particularly, and that's a deep concern. I have to say, it could be that the judiciary could be allowed to make and maintain a list of places they cannot go, or some other rules. There are places here on our island that are specifically designed to allow children to play or whatever. Those people, particularly pedophiles, should not be allowed to go to those places. And, you know, they gave up their freedom when they abused a child. That's the reality. And in fact, I have no sympathy for people who abuse children, people who sexually abuse children. So certainly a law, a bill, an idea to address these kinds of very bad and vicious behaviors, I'm certainly in support of. Thank you.
Thank you, Dr. McNinch. Mr. Enyon?
Thank you again, Madam Chair and Senators. Mr. Perez already raised the question that I had raised with Ms. Titano, but I share these concerns. It's a very fine line. I mean, a sex offender doesn't necessarily have to give up watching sports, but it's very hard to determine the intent. So I support this bill fully because we've got to start somewhere. Thank you very much.
Thank you. Would the sponsor like to ask questions or comment? Is there anyone else who'd like to testify on this bill? Josette. Sorry, Senator Moylan. Okay. Yes, Josette? Or Ms. Titano, is there something you wanted to add?
You know, I just want to reiterate, most of the sentences that come down, they're the judgments. And I'm remembering that specifically when there is a pedophile, they are restricted from being alone with children. As long as there's adults there, that in whatever event, in family events, whatever, it's hard not to have them be a part of the community. I'm just sharing that there is already that law, or most of the judgments have that. As long as there are other adults present. The key there is, as long as the other adults are present, and being watchful of the kids, because it's also, they are already, those who have been convicted of the sex crimes, they know that because it's in their judgments. So I'm just wanting to clarify that, and maybe that'll help somehow. Thank you.
Thank you. Josette?
Thank you for allowing me the time to go ahead and speak on behalf of this bill. I also have some questions just in terms of the implementation of this. What I'm hearing so far is that everyone is talking about an individual's intent. And my question, being a survivor of child molestation, I'm also a social worker. I've also worked with direct victims, direct survivors, policymakers, and I've also taught at the University of Guam. And so I'm very involved in the community, and I've heard a number of reports. My question for all of you is, how do you assess someone's intent? Whether it's malicious, whether it's positive, how do you assess that? So my question is, again, in referring back to the implementation, the community has to be aware. Just as Ms. Titano had mentioned that as long as adults are present, we clearly see in the community that adults being present with other adults, whether it's in a family setting, in a social setting, in a community environment, or even in their own home. Continually, people are continually being assaulted. And so we need to figure out better in a community setting, how do we talk about these issues? I think a lot of the times we believe that we're going to perceive based on our own subjective perspective, but without ever really addressing an issue. And so clearly my focus is how do we assess that? So when you have this kind of bill where people are going to be there based on intent, and then, or even possibly safeguarded by adults, is that doesn't happen. And that's what I'm sharing with you, is that our community does not trust that these bills are really implemented and are really actually going to safeguard our community, whether it's children or whether it's adults. And so that's the question I have for all of you as you proceed in following through with this, is what is how, whether it's an assessment tool, whether it's community education, whether it's rehabilitation programs, a lot of these things I think are just thrown out there, but in reality, are they really effectively working? Are they really effectively protecting? Are they really doing what is the intent of the bill? And so I ask you that question. Thank you.
Thank you. Senator Moylan.
Thank you for the panel. Thank you for the statements and your questions. Your last question, I think, kind of summarized what all have offered in a way. It's interesting that you did ask that, and I appreciate that. Without this current bill, really this panel and what you experience, you have no teeth in enforcing what you really want to do. And you're exactly right. With the parents and with the community's involvement, you can prevent this from happening by escorting the person out, or just by recognizing what's going on here. This doesn't seem right. When you were given the example of the person taking pictures at different games, that person is not just at that school. I have other testimonies where that person has gone to other schools and done the same thing. But it's with this law, if it does become, with the bill, if it does become public law, then the people that are going to say, is this really was the person's intent, is going to be the folks just like you in the audience, what I experienced. When I was at the basketball game, this guy was just acting so weird. All the testimonies will be able to bring forward. And if you're going to follow the due process of the law, at least with this process, with your statements, you now have a bill, hopefully, that will become law, give you the teeth to prosecute, give you the teeth to have that person legally removed. But it's only based on the evidence gathered by your awareness, by your uneasiness of what's going on. Why is this person laying on the car pretending to watch a game and has no intent, no useful purpose of being there to support a family member? Why is this person taking pictures and lying about working for a company, or maybe doesn't even have film in his camera? So these people are out there. These people will continue to be out there, and this hopefully becomes law, will give the community the authority to give their statements to the police officers, to take this to prosecution, to have that person legally removed, and to let that person know you can't do this anymore. And the idea about the pamphlet, I think that's an excellent idea as well. I would like to talk to you more about that and developing the pamphlet and saying this is what you're not supposed to do. It's almost common sense, right? But some people just got to be told and got to be shown. But with the community getting involved, like what you're coming up here, all of you today, and sharing with us, is going to be very helpful, and we can take back and we can make our island a much safer place. So I know the bill is not foolproof, but it just gives you the authority to have some teeth, some meat, and to take action and to fight for your community. So that's the main intent. So I hope I answered your question in a way, and please go right ahead.
Yes, thank you for that. I think where Seth's getting from is that, like you said, it gives the teeth, but the call to action of it, meaning that you can go ahead and create bills such as this, but the community at large doesn't necessarily know the direction of where it's going. So yes, having a flyer or a pamphlet, but specifically for these perpetrators that are on the sex offender registry, is if there is a rules and regulations, which I'm not sure if there are, what specifically is given to the sex offender, can it assist in making sure that these guidelines are on there, or what are the specific guidelines, and what are the rules? If they're going to a game, strictly to be with another adult, and making sure that he's monitored, so that way, that he's monitored, so making sure that he's not taking photos, because, we have a lot of perpetrators out there, and photos that go public, or they get identities of children. So I think kind of where she's going, which I can see it, is that making it mandatory for all government agencies, all schools, pretty much a community effort that implements a task force or a task, something that has to do with, hey, these are the new laws, and these are the certain criteria that we're going to move forward with. So for every bill that you enact, there should be a plan of action on the back end to enforce that. Is that what you're going with?
You know, I mean, at the end of the day, like you said, right? We want to make sure that we come together as a community, right? But we also have to heal together as a community. And so I think to separate the differences is actually going to only harm us. We have to bring it all together. We have to come together as a community with agencies, with not only offenders, but also with survivors, to try to figure out how do we come back together and how do we heal. Because the intent of that is to really heal, is to really rehabilitate, right? And so for me, my thing is, again, going back to even the previous, bills that have been discussed, is the implementation process. Oftentimes what happens is we have this public hearing, then we don't know what happens. The community at large does not understand the process. You're talking about the teeth. The essence of this is the community, and the community itself does not know how to grasp it, does not know how to bite into this. And yet they are the ones who are affected. And so a lot of times there's this misunderstanding, there's just miscommunications. They don't realize that they have the awareness, they don't realize that they have the voice to be able to speak up. And again, that goes back to trust. But if we can create a task force, if we can create awareness, whether it's through flyers, through community education programs, whatever it may be, again, it's going back to being able to discuss this. And if we can discuss, if we're aware of it, then we can address an issue. Then we can further assess how is this going to be effectively implemented into our community. So that way we can all move forward. Because otherwise we are going to perpetuate this cycle of being here and trying to figure out how do we do this. And so my question is, if the intent is to really, really integrate, then how do we do that? But then how do we ensure that everybody is included? And how do we ensure that everyone's intent is the same? Because otherwise, we're never going to be able to break through this cycle.
Okay, I'd like to add to that. That's really good, because that really talks about restorative justice. So when the victim, the offender, comes to a place when it's time after they've done some healing on either side and they come together and they can have peace, then the community is at peace and then we can have that safety. So that's really good. So yes, more education and awareness. And I just also want to share that I just came back from Switzerland. It is so safe, so clean. And you know why I noticed that happen really well? Because the community, everybody from the salesperson at the department store, everybody on the street, those who, you rarely saw law enforcement, but everybody in the community was firm about, if you can't do this, there was a lady a customer trying to buy more than 10 bags. Well, the law said, you can't buy 10 bags. And the lady, the cashier enforced that right then and there and just said, no, that's what they told us, you can't buy 10. And so I heard that more than once. So I'm sharing that it can happen if we as a community are educated, are aware that we can do this and come together to make our community safer and better. It can be done, because Switzerland is a model. Thank you.
Thank you, everyone, again, for your testimonies. I appreciate all that you had to offer and explain. This will, of course, we will take all these testimonies under consideration, and we do understand the intent and what you wish to express. So I appreciate it. Thank you very much. Thank you, Madam Chair.
I also want to thank you, and again, your suggestions are well taken. They are the perennial concern. How do you assess an intent of a person who is loitering? And the statute requires that they will, it makes it illegal if they enter or remain on property while having no legitimate purpose, or if a legitimate purpose exists, remaining beyond the time necessary to fulfill that purpose, right? So it's a hard statute to enforce, because you're going to have to ask people, what is your purpose here? And who the authority is to do that is also a problem for all of us, right? That's not normally what we do, go up to people and ask them, what are you doing here? But the bill does specify who the authority will be. And it puts a huge burden on these people, but maybe a task force is a good idea. I mean, it's going to take the entire community. I totally agree with you on all of that. All of us. We have to do what Dr. McNinch and his class have done, what the Coalition of the Family Justice Center has done, and that is take that sex offender registry in our hands and make sure we understand it, we know who they are, and we spread it around the community in every way we possibly can, because the whole point of it is just to make everyone aware, so that if they see these people, then they're supposed to be able to act somehow to protect their children and students, things like this. But it is a huge burden, on the community to do all of this. But I think it's very clear, and you're right. The police cannot do this for us. Definitely, they cannot by themselves monitor all events and make sure no one's loitering at any of these places, but it hopefully will give them a tool that when they do suspect something or they've received calls, to do a little bit more. Because sometimes now they tell us they can't do anything, there's nothing wrong with hanging around a place, right? So I think we're going to have to pursue some of the concerns that have been raised, ensure that it's, that we've met the constitutional requirements of a statute and that it really will be enforceable. And I agree with you, but we're trying to do that, Josette, is to bring this to the community in this forum. And I agree that many other forums are necessary. So I want to thank all of the community advocates that also use every other forum possible to bring these concerns to light and to help in the enforcement. Is there anything else anyone would like to add? If not, then the hearing on Bill 175 is now concluded, and I will continue to receive testimony until August 7, 2019. The time is now 10:25. So we will adjourn this hearing. And again, you can submit testimony to Senator Terlaje Guam at gmail.com or here to the Congress building. Si Dios masi to all of you.